Hey everybody, JD Hovener here answering your question about patent law. And today it is a question about, can patents be revoked? The answer is yes, in two major ways. The first way is when a patent is granted. The way that the laws are for patent law is they can change. Okay, laws change. And what happens is when a patent is granted, it's really effective only so much that the current laws are able to enforce it. So one thing that can happen is that the federal circuit or the Supreme Court can rule a certain way, and it might affect your rights as a patent holder. This happened most famously about 10 years ago with software, and a really famous Supreme Court case called Alice versus CLS Bank. And it was a case about a patent holder that had a novel, unique way of implementing something that had been going on for a long time at banks, where they just convert foreign exchange currency. And the bank acquired this patent because it was now going to be done on a computer. Well, the judge at this, they went through federal court, went through the federal circuit, and then went through the Supreme Court. They said, you know what, you're really just doing the same thing, but on a computer. And that really just kind of abstracts the idea, and the concept truly isn't all that novel. You're really just doing it now using a computer, a novel process, a novel method of using this computer device, but it's the same process you've always done without a computer in a more analog format. So they said that a lot of these software patents that have been issued in early 2000, 2010, 11, 12, 13, up until that ruling in 2014, that all those patents that were already issued are now to be invalidated. And that can happen, right? Patent laws change, and we've seen that even past 2014 in different areas of law. So while you may have the patent that may be granted in your name, no, it's not locked, right? It's not locked in stone, right? There's nothing permanent about the enforceability of your patent. You're always subject to the laws. The second way that a patent can be revoked is if you are asserting your patent against someone else. Say you think they're infringing your patent claims, and you're going to take them to court. Okay, they've decided to rip you off, and you're threatening them anyway to sue them at a trial at a federal court. One of the first things that the defendant might do is look at your patent and say, you know what, did the examiner miss anything? Can I do some homework up front to see if maybe there's any way that we can invalidate or revoke this patent holder's right before we even have to argue that we're not infringing, or to explain away why the product doesn't actually match up to their claim set. And so that's it. That's what can happen is the examiners are human, right? They're using the best tools and technology they can to find the prior art, to confirm whether the invention was, right, the first of its kind in the world, is non-obvious above and beyond other prior art. But it can happen that they miss stuff. And so especially companies with deeper pockets, just more wealthy, larger companies, can spend a lot of money doing research against someone who is asserting their patent rights. And they can attempt to find more, better, higher quality prior art references, meaning either patents or publications that came before the patent holder when they submitted their application, to try to invalidate the patent that they're being accused of. So those are two major ways that patents can get revoked after they're issued in a way. Hope this was educational, and thanks for stopping by. Take care, buddy. I'm JD Hovener with Bold Patents. Go big, go bold.